So I'm here today with Kristina Wyatt. She is at Persefoni, and she's a lawyer focused on helping companies address their environmental reporting requirements. Thanks so much for being with me today, Kristina.
Patrick, it's so nice to be here. Thank you so much for having me.
Yeah. So first, I wanted to learn a little bit about yourself and your legal background and how you found yourself in this kind of ESG space. And then I'd like to ask you a little bit about Persefoni. But first, tell me a bit about yourself because it's quite interesting.
Yeah, happy to. You might think that I sort of took a wrong turn somewhere because I work for a carbon accounting software firm, and I'm basically a middle-aged securities lawyer who can hardly turn on my computer. So what am I doing at a software firm? But it all kind of goes back a ways. I'm a securities lawyer by training. I worked at the SEC for many years, and then went home and took care of my kids and came back into the workforce at this giant law firm, Latham and Watkins, at doing commercial transactions work, and ended up pivoting at some point into sustainability, and had the opportunity to build the firm's sustainability program, which included not only what we were doing operationally to reduce our own footprint, but also it included our pro bono practice and our commercial practice. So helping our own clients to understand their sustainability risks and opportunities, and to build sustainability programs, and to make disclosures and comply with the law. And along the way, I got to know the person who became the acting chair of the SEC. And when she became the acting chair, that's Allison Heron Lee, when she became the acting chair, she asked if I would come over on a special assignment to work on the climate rule, which of course I immediately said, yes, I would love to do that. And so I went over in from basically February of 2021 until February of 2022 and worked on the climate rule proposal. And then when my year was up, I had discovered this amazing company called Persefoni, which does carbon accounting. So it solves for the problem of how can companies calculate and report their greenhouse gas emissions in a way that's easier than the old-fashioned way of doing it all in spreadsheets and using estimates that might not be well documented. It's a system in software that just makes it easier for companies and gives companies greater confidence in the information that they're reporting. So now I'm Chief Sustainability Officer at Persefoni. Bit of a twist and turn.
Okay. So you're a lawyer at a tech company. So are you in charge of dealing with kind of like the regulatory requirements related to tech, so GDPR and things like that? Or are you more focused on what's the regulation that our clients are going to need to be cognizant of?
Yeah, I mean, exactly the latter. So we have other people who are responsible for privacy and our own compliance. I happen to be responsible for our own sustainability reporting. So that's a piece of our legal requirements, but mostly my team focuses on the regulatory requirements that our clients are subject to, so that we can ensure that our software is fit for purpose to help our clients to be able to comply with the emerging regulations and the existing regulations.
So, and do you and I would expect that some of the key regulations are coming out of Europe as well as the US. Do you want to tell me a little bit about some of the chief regulations that you're thinking about when you're giving solutions to your clients?
Yeah, absolutely. And in fact, I may just back up a little bit and give a little bit of the background of the landscape, because we've really seen a radical change in the last just 2 or 3 years in the reporting landscape. So, and this was really one of the driving forces for me when I went to the SEC, was to try to address what was at the time a very fragmented voluntary reporting landscape, where we had this thing that people called the alphabet soup of all these different reporting standards that created confusion and made it difficult for investors, because they were not getting the kind of consistent, comparable, decision useful information that they were asking for. And companies were also confused. They were under this mountain of questionnaires from investors and other stakeholders. They had the alphabet soup that they were trying to figure out, and just trying to figure out, what should I be measuring? What should I be reporting? And so when I went to the SEC, we worked on a climate rule that helped to define what companies ought to be reporting. But at the very same time, Europe was working on its CSRD, its Corporate Sustainability Reporting Directive, and the ISSB, the International Sustainability Standards Board, was also in the process of being formed by the IFRS Foundation. And so we started to see this really clear direction of travel where we move from this voluntary fragmented reporting landscape to one that is really governed by regulation first and is much clearer and much more harmonized. And while there are differences among the ISSB, the CSRD, California has laws, the SEC rule, there's certainly differences among them. They do follow a clear couple of frameworks that really underpin all of them. So there's much more clarity for companies and much more consistency for investors that they can, that gives them data that they can use to compare companies.
So my memory is there's the TCFD.
Yes.
And then there's the ISSB. And those are two kind of different ways how you're supposed to you input data, you analyze it, and then you report based on those two frameworks. Are those the two main frameworks that companies use?
Well, almost. So the TCFD, the Task Force on Climate-Related Financial Disclosures, was formed back in 2015. They put out their first set of their first framework in 2017, and they were broadly adopted around the world. That's the framework that defines how companies should think about their climate-related financial risks and how they should build their governance and their strategy and set goals and metrics and targets to measure progress so that they can really incorporate climate risk and opportunity into their business planning. And that was well adopted on a voluntary basis by lots of companies around the world. And it was also incorporated into a lot of the alphabet soup of standards, voluntary standards. But then when we came along and built the regulatory requirements, one of the anchor frameworks was the TCFD. So it's enormously important, and it runs through all of those regulatory or standard setting frameworks that I talked about. So the ISSB standards, the CSRD, the SEC rule, and California's laws, they all are built upon this climate risk framework of TCFD. Now, it happens that the TCFD has now rolled up under the ISSB, the International Sustainability Standards Board. So it still exists, but it doesn't exist as a standalone framework. It's now part of the ISSB. The other really important framework that helps companies to report on their climate risks is the greenhouse gas protocol. And that's basically an accounting standard that, again, you'll see across all of these other standards and regulations. It's in the ISSB standards, it's in the CSRD, it's in the SEC rule, and it's in the California laws. And it's the accounting standard that defines how you measure your greenhouse gas emissions. And it's the thing that defines what we now commonly know as scope 1, 2, and 3 greenhouse gas emissions. So those two standards, or those two frameworks, really form the backbone of all of the different reporting requirements that are emerging around the world. And that's good because we've gone from what was quite fragmented to something that's pretty harmonized around those two frameworks.
Yeah, they're like the language that you speak when you're doing this reporting. And now it's a harmonized language where if you're in a Hong Kong company or a US company, you're all using the same language. Now, Hong Kong law might have different requirements for what you report, but the language in which you're reporting it is going to be TCFD and GHG protocol. Okay.
Yeah, exactly. Spot on.
And so going back to the regulations, so the key regulations are the ISSB. So that's a standard setting body.
Yes. So what happens with the ISSB is the ISSB was formed by the IFRS Foundation for the purpose of
Wait,
addressing.
I'm sorry. You said that so quickly as if most of our audience is going to remember. Which foundation set it up?
It's the IFRS Foundation, which is it's a European body that basically is responsible for setting the global financial
Okay.
accounting standards, but they
Okay.
also now have set up the ISSB.
Yeah.
And
Yeah.
it was in recognition of the fact that we were in this fragmented world, and we really needed to have some mechanism to harmonize all of these different voluntary frameworks. And so what happened was that effectively all of the leading both climate and broader ESG standard setters or voluntary frameworks ended up rolling up under the ISSB, and the ISSB took the best of the thinking from all of those, the alphabet soup, and came up with these standards. They've now come up with general standards for reporting on sustainability topics and climate standards, and they're going to be working on other sustainability standards. And the idea was to create a common global baseline that countries could use, so that while the standards themselves don't have the force of law, they don't require companies to report, they can be used by companies on a voluntary basis, but also, really importantly, they give a very clear set of guidelines for countries that want to adopt sustainability reporting requirements. They can look to the ISSB and incorporate those into their own rules. And then in doing so, they can create actual reporting obligations that will be enforceable.
Yeah, in the human rights context, we have the UN guiding principles on business and human rights, and then the OECD guidelines, because the OECD is one of those natural organizations to do something like that. And so that's what companies can use, and that's what regulators use when they start crafting their human rights due diligence laws, like the CSRD.
Yes.
So similarly, when they were crafting the CSRD, and when you were looking into the SEC's rules, you were doing it by reference to the ISSB.
Well, not quite in the context of if you think about the timing, the ISSB was set up basically at the same time as we were working on the SEC proposal. So the processes were independent, but there was some discussion of what best practices might look like.
Well, that was a question I was going to ask. How did you, maybe not coordinate isn't the right word, but how did you liaise with your counterparts in the EU and in the rest of the world who are also regulators looking at these same problems and questions? Would it be just through conferences? Were there working groups?
Yeah, so a couple of ways. The SEC has an Office of International Affairs, and they would share information with counterparts around the world, and sometimes do that through IOSCO, which is the International Organization of Securities Commissions. And that's a way for regulators around the world to discuss best practices, perhaps to weigh in on policy positions, et cetera. Now, it doesn't mean that there was actual coordination, because the SEC operates on its own independently, and it has to go through its own process of writing rules and publishing those for public comment, considering the public comments, and then considering what those rules should include in their final form that will meet the needs of investors in the US markets and meet the SEC's mandate. So it's not so much a collaboration with foreign counterparts, but there's certainly discussion, because there is a goal of harmonizing where it meets each of the regulators' needs.
Well, yeah, and I'm sure your experience in practice has shown you that when there's these multiple different reporting schemes and companies have 6 different surveys that they need to meet and report to, it just adds to a challenge rather than actually addressing the root causes.
Yeah, absolutely. Yeah. I mean, that was really a driving force behind the SEC rule, behind the ISSB, was to try to create more harmonization, because as you say, fragmentation adds cost and it adds confusion. It's not particularly helpful.
And so it has been raised in previous discussions I've had with respect to the SEC rules, that people have questioned why it is that the SEC is regulating climate. Why wouldn't that be something for the EPA? And obviously I have a response to that, but I'd love to hear yours, because I'm sure it's much more nuanced than mine.
Yeah, so the SEC is not trying to regulate climate at all.
Yeah. Yeah.
The rule itself is completely agnostic as to what companies actually do. It's not trying to get companies to change their practices. It's all about disclosure, because investors who are going to be allocating their money to companies need to have information about important matters, including climate change. So to the extent that you're investing in a company that may be subject to material climate related risks, investors deserve to have that information. And so the SEC's climate rule is simply a disclosure rule.
Yeah.
And so agreed.
It's an acknowledgement that this is something that investors have been interested in learning for a while. And the fact that you'd been working in this space for 10 years or however long prior to that is testament to the fact that investors do care about this and companies do care about this. So if we all agree that this is an area of concern and it is a material issue, let's have some standards for disclosing it. Because there have been a lot of different, I mean, the obvious kind of scam that people talk about a lot is certainly greenwashing, but also these carbon credit scams where these nefarious parties are selling carbon credits and not actually utilizing it. How do the SEC rules address issues like scammers, or do they, or is it more related to the companies themselves?
It's all about disclosure again. Now the disclosures are at the company level, but since you raised the issue of carbon credits, that is an area that the climate rule goes into. And so it says, if you're using carbon credits as a material part of your plan to meet your climate goals, you have to make disclosures. In one case, in your financial statements, in a note to your financial statements, disclosing the financial impact of those carbon credits, but also outside of your financial statements and sort of the front part of the document, you need to talk about how you plan to meet your goals if you've made public carbon reduction goals, and the role of carbon credits in meeting your goals, and talk about what the source of those credits is and whether they're verified and what the cost is. So again, the SEC is looking for transparency so that investors have the information that they need to inform their investment decisions. And of course, if companies lie, then that falls into the category of sort of greenwashing, and then it becomes something that could be actionable if the company doesn't tell the truth.
Here's what so I'd imagine the chief regulations that you're hoping that Persefoni and other companies help companies address are the SEC's regulations in the US and then the CSRD in the EU. Are there other kind of key regulations around the world? Does Japan have any reporting requirements? Hong Kong, anything like that?
Yeah, so basically the regulatory framework looks like you do have the EU's CSRD, you have the SEC rule, you also in the US have California's SB 253 and 261, and then the ISSB is expected to fill in the gaps in many other jurisdictions. So Japan is considering the ISSB in adopting its own disclosure rules. The ISSB is very likely to be the framework, the standards that regulators around the world use when they adopt their climate disclosure rules. So, and we support all of them because we're based in the greenhouse gas protocol, and the greenhouse gas protocol is baked into all of those reporting requirements.
Mm-hmm. Yeah. Yeah, so it's kind of like if you're advising a company, you can advise them and say, if you're complying with the ISSB, you're likely going to be in compliance with the other rules. I wonder, are there any interesting areas of divergence between the three rules that are, a function of just the differing ideologies, regulatory ideologies, or anything like that?
Yeah, I mean, probably the biggest area of divergence that directly relates to regulatory ideology is that in Europe, the standard that they use for determining what companies should disclose is based on a double materiality lens. So they're looking at information that is not only material to the company and its shareholders, financially material information, but also information that reflects the company's impact on society. So that double materiality is both financial materiality and impact materiality. And that's quite different than in the US. And the ISSB standards are like the US. They use a financial materiality lens. So the difference between the European approach and kind of the rest of the world is that Europe has this impact materiality lens that it applies.
So then, is that because the CSRD isn't a child of the SEC, of the securities regulators, but it's a separate climate disclosure law? Is that correct? I'm not even sure. Does the CSRD come out of the securities regulators, or is it kind of an independent law?
So, I mean, it comes out of the European disclosure provisions, but the intended audience isn't limited to investors. So it's sort of like securities disclosures, but the audience is broader than than just investors, which is, the key target audience for the SEC and the ISSB.
And then, okay, so that's a very helpful difference. And in terms of, say, the SB 253 and 261 here in California, my understanding is a key difference between the California laws and the SEC rules is that California requires Scope 2 and Scope 3 emissions. Does CSRD require Scope 2 and Scope 3?
Yeah, scopes 1, 2, and 3. So
Yeah.
the scopes of emissions, that's another very big difference. So the ISSB, CSRD, and California's SB 253 all require scopes 1, 2, and 3 emissions disclosures, where the SEC rule only requires scopes 1 and 2 emissions disclosures, and only for the largest companies. So for what are called large accelerated filers and accelerated filers, if those emissions are material. So the disclosures under the SEC rule are more limited than in the rest of the world. Another important distinction between the California laws, SB 253 and SB 261, and the SEC's rule is that the California laws application is different. The companies that it applies to are different than those that the SEC rule applies to.
Yeah.
So the SEC rule applies to companies that are public companies in the US. That could be foreign private issuers, foreign companies reporting in the US, but basically they're companies that report to the SEC.
Yeah.
California applies to, SB 253 applies to US entities that are doing business in California that have $1 billion in revenue. SB 261 is the same definition, but has a slightly lower revenue threshold. So it's $500 million in revenue. Now, importantly, the California laws also apply to private companies. So it's going to capture there's a Venn diagram, right? So it's going to capture some of the same companies as the SEC rule does, but there are some companies that will be captured by California that are not captured by the SEC, and some companies that are captured by the SEC that are not captured by California.
Yeah, yeah. And that speaks again to kind of the constituency, the purpose of the law. The purpose of the California law is it is a climate change law, whereas the SEC rules are mainly an investor-based rules. One interesting thing people often talk about, this will only affect companies that are in scope of the law, but actually it will affect more companies because those companies that are within scope have to acquire information and data from those companies that might otherwise not be in scope. Does Persefoni help companies who are not necessarily in scope but need to obtain data and report to their customers up the supply chain?
Yeah, absolutely. So we actually have a free tool that enables any company anywhere to report their scope 1 and 2 emissions data. And it's for exactly that purpose, to facilitate scope 3 reporting. So if you're a big company that has to, or a small company that has to report your scope 3 emissions, you're really going to want to get that more granular reported data from those in your value chain, whether they're suppliers or if you're an investor, it may be the companies that you invest in. And you can use our free tool to get that information from those in your value chain. And it's all about democratizing.
That's incredibly important, because I have a smaller law firm, so I'm often working with smaller companies, and those smaller companies say, how are we going to deal with this new regulatory burden? And so it's really fantastic to know that there are companies like Persefoni offering these tools.
Yeah, thank you. Yeah, we're really proud of the tool, and you can just go on persefoni.com and sign up and use the free tool. I encourage you to check it out.
Mm-hmm. Yeah, I might have to for my law firm. My law firm's pretty green for the most part.
Well, good.
Yeah.
Good.
So this has been really interesting. So we've talked about a lot of really different, interesting areas. Do you want to talk a little bit about the implementation of these laws, and particularly how companies have approached implementing the laws, particularly given the fact that there's legal challenges to the SEC rules and the California rules?
Yeah, I'm happy to. So what we're seeing, this really goes back to the common 2 lanes of travel and how important it is that we have that harmonization, because without that, I think people would just be scratching their heads and trying to figure out what on earth to do.
Yeah.
But because we have these common lanes of travel, we have the greenhouse gas protocol to define how you should measure your greenhouse gas emissions, your scope 1, 2, and 3. You have the TCFD, the Task Force on Climate-Related Financial Disclosures, that helps you to think about your climate-related financial risks and how to report. And because those are the common lanes of travel through all of these regulatory requirements, we're seeing that companies know what they have to do to get ready. And so they're calculating their greenhouse gas emissions. They're setting up the governance structures that they need to in order to properly oversee and manage their climate-related financial risks. They're assessing their physical and transition risks. They're building strategies to address those risks and take advantage of opportunities. They're setting goals, setting up structures to measure their progress toward those goals. All of those are the things that companies will need to do to be ready for reporting, whether that reporting is voluntary pursuant to the CDP, say, or pursuant to one of the countries that adopts the ISSB, or pursuant to the CSRD, which is going to have very broad effect even outside of Europe, pursuant to California, pursuant to the SEC. So it's sort of like, we know the things that have to be done. There's still question marks around exactly what is going to have to be disclosed where and when. And that gets to some of the litigation and some of the uncertainty. But the things that companies need to do to get ready are pretty well defined at this point, and that's helpful.
Okay, yeah. At this point, the companies need to implement their procedures and start collecting information, and they know the type of information they need to collect, and they know the language with which they need to report, exactly what they need to report, what boxes need to be ticked. That's subject to your specific jurisdictions that you're reporting into. And we're hoping that over the years that will even be harmonized, but that harmonization process will only come once the laws take effect, the reporting takes effect. So companies are reporting for the CSRD this year, right?
The first companies that are reporting to the CSRD are reporting this year. Probably the biggest date for when all companies are going to have to report, including, say, U.S. parents of companies doing business in Europe that are in scope, will be 2028. So it's going to be a phase-in period between now and 2028.
Mm-hmm. And so lawyers' role in that is basically informing companies that this is a real obligation and getting them ready to report. Right.
Yeah, I think so. And also really helping companies to set up informational governance systems to ensure that whatever it is that they're saying about their climate related financial risks, about their greenhouse gas emissions, is consistent across the various avenues that they may be disclosing, and that they have confidence in what they're saying. Because, of course, as you know, the SEC doesn't just look at the information that's in your 10Ks or your registration statements. It also can look at information that is anywhere. So in your sustainability reports, in your on your websites, et cetera. Same with plaintiffs' lawyers. So that need to kind of build that information governance and bring controls around the information that you're putting out is just critically important, particularly as we move into this regulated environment.
Ensuring reliability of information. We talk about that in the context of greenwashing litigation, and developing a compliance structure for greenwashing litigation requires you validate the claims that are made. And oftentimes it requires a little bit of calculated pushback and a bit of lawyering to say, okay, you've said this. Why do you say this? And can I argue in court that the reason why you said this is, and similarly, if I was arguing on behalf of a shareholder derivative suit that there are these statements made, why is it that you made these disclosures, and are they credible?
That's right. And can you show your work? So if you put out greenhouse gas emissions numbers, what backs that up? And can you show how you derive those numbers? And again, that's where software is critically important, because it gives you that system of record where you can show your work.
How do you address the fact that, particularly for scope 3, you're effectively asking other people to provide the information? So how is it that a company would be stress testing information provided by others? Do they have to stress test it, or can they just accept it full skip?
Yeah, I mean, again, that's where, we really encourage companies to use software like ours, where at least you have a record of the input data, the emission factors applied, the calculations used, so that you can have greater confidence in the data that's feeding into your scope 3.
Yeah, because I would imagine that it's something like, if a supplier tells you they have 0 emissions, that's not credible, and so you need to push back on that. But at some stage, there's a sliding scale of credibility, and so finding where that kind of balance point is in the sliding scale is interesting. So maybe just for a second, we can talk about, are companies in the US pausing their implementation of these climate-based disclosures, given the uncertainty that's caused by some of the litigation against the enactment of SB 253 and the SEC rules? Or are you finding that companies are effectively accepting that they're going to be reporting something, and the extent of their reporting may be a question?
Yeah, I mean, we're seeing a lot of companies getting ready. So yes, there's still a question of when they're going to have to report what and where. But I think the handwriting is pretty clearly on the wall that most companies are going to have to report this information somewhere. And even if they didn't have regulatory requirements, the pressure from investors, from stakeholders, from companies that you do business with, from employees, from all around, is not going away. And the risk associated with climate change, whether it's physical risk or transition risk, is increasingly being recognized as something that, can materially impact a company's viability, its ability to deliver the goods and services that it's promising to its stakeholders. And so it's just it's a part of good business to start to really measure and manage your climate related risks.
Yeah, and although companies might think that at this point, because it's voluntary disclosures, they don't have to be as deliberate about being accurate, they have to remember that in a few years they will be subject to requirements, and so you wouldn't want a massive discrepancy between what you're reporting in 2024 and what you're reporting in 2027. So it's
totally. And also, remember that companies are still subject to 10b-5 to the anti-fraud rules under the Securities Exchange Act, for information that they're putting out. So you want to ensure that, you've made good faith efforts to be accurate. And you're exactly right. Of course, in addition to that, even leaving aside fraud, you are going to have to report this information. And so you want what you're reporting now to be sort of consistent with the reporting that you're going to be doing a few years from now.
Okay, so this has been a really, really helpful set of background on where we are with respect to disclosure laws. I wonder, now that you've given us the background, maybe looking forward, where do you see the legal landscape evolving in the future?
Yeah, I mean, I think from a reporting perspective on climate, we're just going to see a maturation of the information that companies are putting out. We'll certainly see litigation over companies greenwashing. That's inevitable. We'll see litigation around the use of offsets and offsets that aren't real. That's inevitable. But we're also going to see an improvement in the quality of disclosures that companies are making, just as a natural evolution of the process as companies get used to this kind of reporting, just as happened with Sarbanes-Oxley when that was passed and companies had to change their accounting systems. The quality of the data became better, but it was a process of getting used to it. So, I think that's one thing. We'll just see better and better data and more comfort with reporting this information. And then also we're going to see reporting on broader categories of sustainability topics beyond climate. So the CSRD out of Europe is quite broad, and it covers a whole range of sustainability topics, ESG, so environmental, social, and governance. The ISSB will be working on standards that go beyond climate. So looking at nature and biodiversity, water, eventually we'll get to social issues, et cetera. So I think that's another evolution. And all of that kind of falls within the category of companies looking around the corner and not just addressing the thing that's right in front of them today, this quarter, but thinking about what kinds of risks and opportunities do I have that relate to my engagement with the broader world? If I have human rights violations in my value chain, what kind of risk does that present for my company? If my carbon emissions are significant and I've set net zero targets, but I don't have a plan to meet those targets, then that creates risk for the company, et cetera.
So I have two other questions. One question is there any progress in general? It's 2 steps forward, 1 step back. Is there any thought that some of these disclosure requirements might be ground to a halt in the future or reversed? Or are you confident that the trend is going towards more and more disclosure?
I'm confident that the trend is going to more and more disclosure, but that's companies voluntarily disclosing. It's hard to know what the regulatory landscape will look like. I think, the ISSB has taken hold and countries around the world are implementing it. And so that seems fairly certain. The CSRD in Europe is taking effect. So that seems fairly certain. Obviously, there's litigation against California and the SEC, so there's more uncertainty there. I believe that both of those, the California laws and the SEC rule, will survive the litigation, but it's conceivable that for example, the SEC rule could be pared back. It's hard to know that. But the thing that we do know is that companies are reporting this information, and the greatest indicator of that is just the continued very significant uptick in reporting to the CDP, what used to be known as the Carbon Disclosure Project, which now has 23,000 companies that are reporting into it. And that's companies that are voluntarily reporting because their stakeholders expect it, because it's a part of their doing business. So I don't see this going away. yes, there are questions about where exactly the regulatory landscape will end up, particularly
Yeah,
in this country, but you know, the
yeah.
reporting is happening, and it's going to continue to happen, and it's going to get easier, and it builds on itself. So the more companies that report on carbon, for example, the more good data there is out there that can inform other companies reporting. So you can see virtuous cycles starting to develop, or networks starting to develop, and that's to be expected, and that's good.
And then one other question I wanted to have, you would have an interesting perspective on this because you were a practicing lawyer at Latham, then you were at the SEC, and now you're at a service provider. So I'd imagine that you probably liaise with a lot of lawyers who are advising companies, and you're a tool provider. Do you think that there's any kind of advancements required in the legal profession so that it can better serve, we can better serve our clients with respect to disclosure laws? And, maybe we can just talk a little bit about that to end, where you
Yeah.
think there are gaps in the legal profession.
Yeah, I mean, I think that there's a lot of education that's going on right now, and lawyers are learning. This is all relatively new. I mean, obviously, companies have been reporting on climate for a long time. They've been concerned about climate for a long time, but we were in that fragmented environment. And so, this harmonized single direction of travel, or parallel directions of travel, is somewhat new. And I think there is a tremendous amount of education that's happening, and it's happening at law firms, it's happening at consulting firms, it's happening at accounting firms, it's happening at companies. And so I do think that there will be some evolution in that regard. And tools like ours will certainly help. I mean, the reason I went to the SEC from Latham was that I had been working in this fragmented environment where our clients were just saying, tell me what to do. Or our financial services clients were saying, we just want to have consistent, comparable information. And so I went to the SEC because that was the really felt need at the time. We needed to build regulations that would drive harmonization. And then when I left the SEC, the felt need was that we needed to have tools to help companies to be able to report in a way that was less painful, less difficult, less time intensive, less expensive, and more reliable and useful for companies. So I kind of felt like I could go back to Latham, I could go back to a law firm, but without these tools, I'm not going to be as effective in representing my clients. So I think that it's a key step. Having these tools is key to helping companies, but also helping law firms in representing their clients. Having that tool to help what are my emissions and where are they, and what levers do I have that I can use to reduce them, and how much will that cost, and how can I model that out? All of that is a part of the real work of managing your carbon emissions, and doing that on the back of an envelope or on a spreadsheet is just not feasible, whereas software makes it much easier.
Yeah, no, absolutely. I say the same thing in the context of human rights issues, where right now we're at the stage where there's starting to be a bit of an understanding of what's required, but getting to the point where we have sophisticated tools to implement those solutions is still an ongoing process. And
Yeah.
so, well, this has been really, really fantastic. I really appreciate you coming on and speaking to us a bit about this. Is there anything
Well,
you wanted to
thank
add
you.
before we go?
No, I just want to say thank you. It's been a blast. I've really enjoyed talking with you, and really appreciate your having me on.
Well, we really appreciate the work you've been doing in this space. So thanks
Thank
very
you.
much. You
Thanks.
have
Bye
a good
bye.
rest of your day.
You too. Thanks, Patrick.